Welcome back to this final segment in this law session relating to judicial precedent. Now, I said to you that we would finish this off, of course, by looking at some judicial activism, and I also wanted, of course, to take account of the position of the House of Lords, or the Supreme Court as it is now known. Now, in the mid-19th century, the House of Lords developed the practice that it would be bound by its own decisions. So this was in the 19th century. They did reaffirm this in 1898 in the case of London Tramways and London County Council. Now, the House of Lords felt that the decisions of the highest appeal court should be final in the public interest so that there would be certainty in the law and an end to litigation. However, this practice was heavily criticized and kept on being so from about the 1930s. Now, some of the law lords said that the rule did not produce the desired certainty in the law and it had become too rigid. Persons, of course, were saying this: Lord Wright, Lord Denning nonetheless, Lord Reed. But the practice was not changed until 1966 by Lord Gardiner, who was the Lord Chancellor, who, through the practice statement, which I would urge you to read, he set out the practice statement, and it was accompanied by a press release which emphasized the importance of and the reason for the change. It said it would enable the House of Lords to adapt English law to meet changing social conditions. It would enable the House to pay more attention to decisions of superior courts in the Commonwealth, and the change would, of course, bring the House into line with the practice of other superior courts around the world. So the idea is that it would make them a Supreme Court. Now, Patterson's survey of 19 law lords who were active between 1967 and 1973 found that at least 12 thought that the law lords had a duty to develop the common law in response to changing social conditions. And you can see this in Patterson's book, The Law Lords, published in 1982. Now, I would urge, as I say, to look at the practice statement because it looks at what the House of Lords was about, and then it looks at the path that they were intending to take, the idea being that they should not be restricted, that what they had done before ought not to be binding, and so they could depart from a previous judgment in respect of developing the common law. So, when you look at the reasons, this idea that, it is to allow the law to breathe, it's a living, breathing thing, there are some reasons which will not be considered valid for review. So just because the decision was wrong will not be sufficient for the Supreme Court to depart. That the earlier decision was by a narrow majority, irrelevant, because the decision caused grave concern. Again, not going to let the decision be changed. Issues which are only of academic interest will not be entertained, and usually you have to show a material change of circumstances. The case to look at for that is Fitzleet, Fitzleet, Estates, and Cherry. Now, when you look at judicial activism, when you look at the judges taking a pretty active role, I would urge you to look at the stance taken by Lord Denning in particular, because he was very mindful of the law needing to be developed. Now, he, of course, was promoted to the House of Lords. He came back down to the Court of Appeal because he felt, of course, that was where best he could make law. Because, as we said before, the vast majority of cases end in the Court of Appeal. Now, if we look at some examples, and we start off with the Harrington and British Railways Board. This is a 1972 case where the House of Lords overruled a previous case called Addy and Dumbrick. Now, in Addy, the House of Lords previously had held that an occupier of premises was only liable to a trespasser who was a child who was injured by the occupier intentionally or recklessly. In Harrington, the House of Lords said that a different approach was appropriate in the changed social, and physical conditions since 1929, and they propounded the test of common humanity, which involved an investigation of whether the occupier had done all that a humane person would have done to protect the safety of the trespasser. So the idea is, if you're looking at a trespasser child, then you should not follow the standard common law principle of, well, if somebody comes on your land, they come on there at their own risk. In the case of Millie Anderson, George Frank, which is a 1976 case, the House of Lords overruled a previous case, Reunited Railways, because in Reunited Railways it had been held that damages in an English civil case could only be awarded in sterling. Now, in Millie Anderson, George, the House of Lords said that damages can be awarded in the currency of any foreign country which is specified in the contract. A new rule was, of course, needed because of the change in foreign exchange conditions, and especially given the instability of sterling since 1961. The idea then is that when you look at the judges and them considering matters before them, you will see that the judges tend to be a little bit more active. Cases like, for example, Anderton and Ryan, cases like Shivpuri. Look at how the textbooks have dealt with these, where, for example, you are looking at the courts interpreting a statute and dealing with the matter before them. We see, for example, in Ryan, she escapes criminal liability. Shivpuri, unfortunately, wasn't so lucky. He was found guilty. The point then is, how do you reconcile these decisions? And the point, of course, is to look at how the judges have been active. Like I keep saying, the one that you will look at mostly is, of course, Lord Denning, because we see a lot of times that Lord Denning departs from the normal position, but then at Court of Appeal level, but then we get the House of Lords chastising him, but still finding along the lines that he did. Another case to consider is a case called Conway and Rimmer, which was overruled subsequently. So they're both House of Lords cases. Conway and Rimmer overruled by Duncan and Camilleard when you look at discovery of documents. Now, Duncan was decided in wartime and was probably correct on its facts, which said that an affidavit sworn by a government minister was sufficient to enable the Crown, the government, to claim public interest immunity or claim privilege not to disclose certain documents. Now, when you look at that, we see that the courts have moved on from there. When we look at the case of R&R and the marital rape scenario, again, we see a situation where the courts have moved away from previous judgments. Now, when we look between 1966 and 1975, we see that there has been some activity in relation to the practice statement. We see Lord Reed saying there are 7 criteria when you look at the use of the practice statement. He said 5 are negative, 2 are positive. He says you look at the freedom granted by the practice statement and it ought to be exercised sparingly. It should not be used to upset the legitimate expectations of people who have entered into contracts or settlement which are have regulated their affairs based on the validity of a decision. He said it should not, on the question of construction of statutes or other documents, except in rare and exceptional cases, and it should not overrule if it would be impracticable for the Lords to foresee the consequences. Equally, it should not overrule if to do so would involve damage that ought to be part of a comprehensive reform of law. He's trying to say judges should not be parliamentarians, right? He says it should not merely be because the law lords consider that it was wrongly decided. There must be some additional reason to justify such a step, and you should overrule if it causes such great uncertainty in practice. It should overrule if in relation to some broad issue or principle it is not considered just or in keeping with contemporary social conditions. So when we look at the guidelines, you have to be very careful. You look at cases like R.V. Clegg, which looks at the guidelines, and we look at cases like R&R, again, which look at the guidelines. So overall, you must consider how the cases have panned out in this regard. So for example, in a case of CNDPP, the House referred to the anomalies and absurdities produced by the rebuttal at common law, this rebuttable presumption that a child between the age of 10 and 14 is incapable of committing a crime. Nevertheless, albeit the criticisms, they refused to abolish the presumption, preferring instead to call upon Parliament to review it. Now then, when you look at this approach, when you look at the cautiousness that the House of Lords has taken, in contrast with the specific active judicial role that somebody like Lord Denning has taken, again, I would urge you to look at that. You will see that there is an argument to suggest that judges make law, but how you explain it is to say that in the context of actually interpreting, that is where it actually makes sense. So Airedale, NHS Trust and Bland, when you look at Gillick and Norfolk, these are cases where we see moral issues being considered, the courts taking an approach, but by and large, it being largely left to Parliament to consider. One case that is one of my favorites, which I would certainly ask you to look at, is the case of A. N. Horn 2008. When we look at the contemporary issues relating to judicial activism, if you look at this case, it's the Lotto rapist case. Now, it was about looking at what was the law before. And on the 22nd of February 1988, the defendant, who was someone who had subjected the claimant to a serious sexual assault, he initially pleaded not guilty, but was subsequently convicted of attempted rape, sentenced to life imprisonment. He was released on license on the 10th of May 2004. This means he's in prison. He can come and go as he pleases. He won £7 million on the National Lottery. On the 22nd of December 2004, the claimant brought civil proceedings against him for damages for assault and battery resulting in psychiatric injury. Remember that for every crime you have a tort, she brought her action. The claimant's claim at the time was statute barred, meaning that she had run out of time. But the idea was that it went to the House of Lords, who held that a previous case, Stubbings and Webb in 1993, was wrongly decided on the issue and allowed her to bring her action. Again, I'm going to leave you with Lord Denning, Master of the Rolls, who had carried on a one-man campaign to secure a change of practice in the Court of Appeals. He seemed to attack the approach on two fronts. He asserted that the House of Lords decision no longer bound the Court of Appeal, and he claimed that the Court of Appeal was no longer bound to follow its own decisions as a general rule and not just in the exceptional situations set down in Young and Bristol Airplane. Please look at how Lord Denning has done some development in the common law and look at the attitudes. That brings us to the end of judicial interpretation in respect of precedent. And certainly I would ask you to make sure you listen to the law session on statutory interpretation.